Okay, good morning.
Morning, Your Honor.
Good morning, Your Honor.
Good morning.
So we have first a motion, an amended motion to intervene and or to consolidate. So is Mr. Silver here?
Yes, I'm here, Your Honor.
All right, so Mr. Silver, I take it from your amended motion, the order transferring to Leon County from Broward County has not actually been signed yet?
It may have been signed as we speak now, but as of like 4 in the morning yesterday, I don't think it was. So I don't know.
Hold on just a second. Okay, Mr. Silver.
Yes.
Can you give me the 1-minute version of your motion? I've read it. If you like to restate it.
Sure can. I think there's no prejudice to anybody. It would help.
You don't think the defendant needs some time to prepare for your case?
No, the governor's attorney has already been involved, a different one, but I believe they're in collaboration or conversation with each other. They've heard it. The issues are identical, and there's nothing new here. And so I don't think that there's any need to prepare. If there was, they have the means to do it because the other attorney, Andrew King, who I believe is working with these attorneys, he represents the governor. So I think they're fine. I don't think there's any prejudice here. And I think it would certainly help to to avoid inconsistent rulings, and it would take a lot of time. So for judicial economy and a lot of other reasons, it seems like there's a lot of reasons why you would want to consolidate or at least intervene and no reasons not to.
All right, does the plaintiff have a position? In this case, the plaintiffs in this case, do they have a position?
I do, Your Honor. Craig Wisenhunt for the record. Mr. Silver's complaint represents a substantial different theory of the case than what the plaintiffs here are prepared to address. Specifically, Mr. Silver has alleged that the executive order on its face, due to its language, is inherently unenforceable. That is not the position that we have taken in this case. Moreover, as there hasn't been an order transferring jurisdiction to Leon County, I don't believe that this is a timely request for intervention. And of course, where the rule does allow permissive intervention of the case in the discretion of the court, it would be subsidiary to the primary claim. My concern is that Mr. Silver bringing this new issue and new plaintiff in at the literal last moment before trial would unnecessarily complicate our prepared theories of the case and presentation. So we'd be asking that you deny the motion for intervention at this time.
The defendant, Mr. Abel, does the defendant have a position? Defendants have a position?
Your Honor, the defendants do not oppose the motion Mr. Silver presents to the court. We would ask, however, that if the court grants Mr. Silver's motion, that Mr. Silver provide as quickly as possible an exhibit list and a witness list so that we are prepared to, so that we can be prepared for whatever evidence he plans to present.
Your Honor, if I may, addressing the plaintiff's concerns, I have no issues of not bringing up a separate issue if that's going to be a problem for them. I thought it would be a problem maybe for the defendants, but if the plaintiffs have a problem with me bringing up a different issue, I don't need to do that. And I'm happy to, I don't intend to bring up additional witnesses and experts and things like that. I'm perfectly willing to rely on what's already been presented. I don't want to delay the proceedings in any way. And so I'm willing to rely on their experts and their witnesses. And so I don't anticipate there are any additional ones, but if there are, I'll be glad to provide it. And if your Honor is inclined not to consolidate, then I would at least ask to be able to intervene. And I just want to share with your Honor what you already know, that this is a court of equity. And so in order to bring about a fair adjudication of the issues, whether the judge has signed it or not, really shouldn't be determinative. It's already been sent to the judge. Both sides agreed on the agreed order. It'll happen momentarily. It might have already happened, I don't know, but I don't think that should be an impediment.
Well, Who did you sue, Mr. Silver?
We sued the governor and the state of Florida.
You didn't sue Commissioner Corcoran? You didn't sue the Department of Education, the State Board of Education?
No.
Okay, I'm going to deny the motion. We're in the first day of trial. It's simply too late to add another party in, even to intervene. I haven't even had a chance to see the complaint. The case is not actually in Leon County, as I know at the present time. It'll be assigned to one of 3 judges by the assignment computer. I don't even have any idea who it would be assigned to. Maybe me, maybe one of the other 2. I just don't know. I just think it's too late, and I don't see any prejudice to the movement in the event the movement wishes to proceed with his case, proceeding on, and whether it's the judge in that case reaches a different result or not, there's no way for me to know. There are different parties and potentially different issues, so I can't judge that. I just think it creates far more problems than anything it solves. And I hardly ever deny a motion to intervene, but I've never had a motion to intervene or to consolidate on the first day of a trial. That's never happened. So, but I'm going to deny the motion. I'm going to ask Mr. Gallagher's firm to prepare just a brief order, and you can state for the reasons stated on the record, the motion is denied. Send a copy. Send it to Mr. Abel's firm. Send a copy into Mr. Silver. Send the order to my judicial assistant by email. At some point, I'll find time to sign it. Let me ask this question. I have no idea if you sent me an order yet on the ruling on the motion to dismiss. Has that been done? I don't recall seeing it.
We have not yet, Your Honor.
Okay, I think it'd be a good idea if you send that to me also. And again, it can just be for the reasons stated on the record, the motion to dismiss is denied.
We'll do that, Your Honor.
Do not have the time to draft orders. Yes, Mr. Silver.
Yeah, I just want to clarify. My understanding is that when my case does officially get involved with Leon County, it would almost assuredly be consolidated, or not consolidated, it would be assigned to you, is my understanding. Is the case.
That's true, then you don't have to worry about inconsistent rulings.
Yeah, I just wanted to clarify that with you, if you think that would be the appropriate thing to do.
I don't control over how it's assigned. That's a function the clerk does. It's done by what they call a computer counter, and the computer weighs the number of assignments per judge. And when one case goes to this judge gets the next case, et cetera. So I have no control over that. I can't say what's going to happen. It's like me saying what's going to be the first play called at the FSU Notre Dame game. It hasn't even happened yet. I don't even know who the starters are. So it's not enough information for me to tell you what the first. I can tell you it'll be a run or a pass most likely, but that's about it. Yeah. So I'm sorry, but your case is not over. It's just not going to be included in this case.
Yeah, okay. I know you haven't read the complaint, but the complaint is virtually identical to the complaint that's already been filed, and it was first filed in this state. It's the first one filed. So it's not, there's no different issues. And the defendant state of Florida is merely another way of saying the governor. There's no
I don't agree with you on that. I'd be surprised if Mr. Abel agreed that if you sue the state of Florida, that's the same thing as suing the governor. Or do you agree with that, Mr. Abel?
No, we don't agree to that.
Yeah, I didn't think you would. All right, so
okay.
The motion, thank Mr. Silver, I appreciate it. The motion's denied. We have to move on. I'm going to ask that y'all not stay on Zoom, but you can, through the Second Circuit Court website, you can watch this on YouTube. And there's a little up at the top right-hand corner, just click on the YouTube and you can see the whole proceeding. I'm also told that the Florida channel is recording and airing. I don't know if it's all of this or parts of it, but it's now playing live on YouTube. So
thanks, Your Honor. Okay.
Thank you very much. And Mr. Dowling, thank you. Okay, so is there anything we need to take up before we start? Let me make a note here, counsel, on my computer here. Just a second. Motion to dismiss, what was that, last Thursday?
Right.
Thursday, denied, and motion to intervene today, denied. Hold on. Orders being sent by the plaintiff's counsel. Okay. So anything we need to take up before we start opening statements?
As a preliminary matter, the plaintiffs are amenable to waiving predicates for the exhibits of both parties for expedience purposes and for just getting us quicker to the issues.
Mr. Abel, what's your position? I've looked at, Mr. Abel, I've reviewed your exhibits that came in Friday. I have not reviewed the plaintiff's exhibits, which came in today, or I think, Mr. Abel, there was some substituted pages. I haven't reviewed those, but do you have an objection to the exhibits coming in without testimony?
Your Honor, on review, some of the plaintiff exhibits are objectionable, and we would raise those at the time that they're
all right. Well, what's good for the goose is good for the gander. We'll just have to go through each exhibit and determine whether it's admissible or not.
Your Honor, maybe also during a break or a recess, we may be able to confer with Mr. Gallagher and reach some agreements up front to streamline this. Both teams were preparing quickly for court, and so, but we'll talk with counsel as well.
I understand, Mr. Abel and Mr. Gallagher. If the two sides need additional time to do that, I'm more than happy to grant you whatever time you wish in that regard. So the court reporter and I are going to be taking breaks about every hour or so anyway. So I'll ask the court reporter to please, A, let me know if someone hasn't said who they are and you don't know who they are. And B, if I'm not calling a break fast enough, let me know that it's time for me to do it. So.
Thank you.
Okay.
And the other issue is we invoke the rule, which that might mean Dr. Unesh has to dip off for a little bit.
Okay, so the rule of sequestration has been invoked, which means none of the potential witnesses, Mr. Abel, can hear the testimony or discuss the case with each other. I think it's still appropriate for a lawyer to talk to his or her witness, but otherwise the witnesses don't need to watch the YouTube channel or read anything that might be said about the proceedings until they're finished testifying, and then they're, of course, completely welcome to observe like anyone else. So I'm looking on here.
Dr. Unesh is our first witness after opening, so if you'd like, we can have him just log off briefly and then call him back to log on.
Who's your first witness?
Dr. Unesh. He would not hear any other witness testimony prior to his testimony.
I'm looking on here.
Bob Unesh.
I don't see him on the Zoom.
Sorry, this is Thomas Unesh. I'm logging in from Idaho on my brother's computer because I'm actually on vacation at the moment in Idaho fishing. So I'm on my brother's computer.
All right. So how do you want to handle him, this first witness? Do you want him to sign off of Zoom? I suppose I could put him in a waiting room if I can figure out how to do that. Hold on a minute. Participants. Enable waiting room. It's enabled. I didn't think you were going to pull a surprise on me the first thing and you have to use this computer.
Sorry.
I would ask retired Judge Dodson how to do it, but I've got a feeling he and I are on about the same wavelength when it comes to computer skills.
Your Honor, you're way ahead of me.
Thank you. I do have waiting room enabled. I just don't know how to get this witness into the put in waiting room. Let's see. Done.
In there. Look at that. Impressive.
Okay. If I can get him out, that's a big question too, but we'll see. That's a first for me. So let's see what other firsts we have. I would like to keep the openings to 30 minutes aside. So I want to keep this moving pretty fast. I want everyone to have enough time, but I think we need to move as quickly as we can. And so it's 9:49. Today is August 23. So we start with plaintiff opening. Who would like to make that?
Your Honor, this is Charles Dodson. I'll be making the opening statement for the plaintiffs in the case. And first, Your Honor, I want to thank you on behalf of my co-counsel, our clients and opposing counsel for placing this on your docket so quickly. I know you have almost 1,000 cases assigned to you and a very busy docket, and we thank you for expediting this hearing. It is certainly an emergency.
Well, thank you. By now, it could be over 1,000. So they keep mounting every day, but
yes, sir.
I'm still under 1,000.
I understand that. Yes, sir. And I'm very confident you've already thoroughly prepared for this hearing. So I'll keep my opening statement brief. I hope it'll be a helpful roadmap for you to better understand the evidence we present in the case.
Mm-hmm.
As you know, Florida's public schools just reopened a few days ago for this academic year. The COVID-19 pandemic has affected everyone's lives in this country for now over 1.5 years. And now we have the Delta variant. This already horrible pandemic has been made drastically worse by the Delta variant. The Delta variant, is vastly different from the original COVID-19 strain. The evidence will show it's much more contagious. Hospitals throughout the state are again nearing capacity for COVID-19 patients. Neither vaccinated individuals nor children are immune from infection by or transmission of the Delta variant. Consequently, the Center for Disease Control, the American Academy of Pediatrics, and numerous other medical experts and groups have stated that given the status of the Delta variant, we should have mandatory masking in schools. Children under the age of 12 cannot be vaccinated. We are not asking the governor to mandate masks, but only that he allow local school boards to do so without punishment, should they so choose. This case, Your Honor, we believe is governed by the Florida Constitution, which is the foundation for everything that our government is based on. We look first to Article 9, Section 4B of the Florida Constitution, which provides that the local school boards shall operate, control, and supervise all free public schools within a school district. Again, that provision provides the local school boards shall operate, control, and supervise all free public schools within a school district. It doesn't say the school boards have that duty unless the governor wants to. We believe, according to the Florida Constitution and that provision, each local school board, and only each local school board, should be able to decide for each school district whether masks should be mandatory. You are going to hear testimony from several of our clients, parents testifying for their children. These parents must protect their children. The children cannot protect themselves. You are going to hear these parents' valid concerns for the safety of their children while in school, while this Delta variant is rampant. Again, those children under age 12 can't be vaccinated, and they very well can and are catching this very contagious and very dangerous Delta variant and spreading it. You are going to hear testimony from several physicians of different medical specialties. They will explain more thoroughly the Delta variant, how it is transmitted, and the effect it has on our children. They will explain to you why masks for everyone in the school is an essential factor in making our schools safe for our children. Why masks are so important in reducing the susceptibility of our children from getting this disease and our children spreading this disease. The other provision of the Florida Constitution you're going to be hearing about is Article 9, Section 1, which provides the education of children is a fundamental value of the people of the state of Florida, and that it is a paramount duty of the state to make adequate provision for the education of all children residing within its borders. It further provides that adequate provision shall be made by law for a safe and secure system of free public schools. Because of the Delta variant, our public schools are not safe and secure at this time unless everyone wears a mask. Of course, private schools are not subject to the governor's executive order. Private schools can mandate masks, but public schools cannot. But our children in our public schools are just as precious as those in private schools. We believe the governor's executive order and the accompanying rule are arbitrary and capricious. The glaring whereas clause in the governor's order, which purports to provide the scientific basis for this order, states, whereas despite recent Centers for Disease Control and Prevention guidance, forcing students to wear masks lacks a well-grounded scientific justification. That's what the governor states in his executive order, and there will be very plenty of testimony that will state that there is a well-grounded scientific justification for the CDC's order. The governor then goes on to state, indeed, a Brown University study analyzed COVID-19 data for schools in Florida and found no correlation with mask mandates. So the governor is saying, don't pay any attention to the CDC and look at this Brown University study. The evidence is going to show this Brown University study that the governor bases his order on is sort of in the draft stage. It's under peer review. The evidence is going to show that, and the evidence is further going to show that that Brown University study was based totally on pre-Delta data and did not even take into consideration the rampant Delta variant that is going through our country and our schools right now. This order by the governor and the accompanying rule were arbitrary and capricious efforts to accomplish something very dangerous to our children. Again, the evidence is going to show that not only can children in our schools contract the dangerous Delta variant, but they can take it home and spread it to friends and family members. Our hospitals and medical care providers are overwhelmed. This is an emergency. At the close of this hearing, we will be requesting that you enter an order enjoining the governor and the education commissioner from prohibiting local school districts from requiring masks of all students, faculty, and staff should they choose to do so. Again, Judge Cooper, thank you very much for your attention to this case, and we look forward to presenting our evidence to you.
Okay, thank you, Mr. Dodson. Why don't we go, excuse me, to the defense. We'll hear your opening, then we'll see where we are on the witness and decide if we need to take a break at that point. So it's 10 o'clock, 10 to 10:30. I'm going by my watch. So who would like to make the opening for the defense?
This is Mike Abel, Your Honor. Can the court hear me? Excuse me. Can the court hear me okay?
Yes, I can. Thank you.
Okay. Thank you, Your Honor. And thank you, Judge Dotson and counsel. May it please the court, Mike Abel with my partner Daniel Bean and Jared Burns. We're here, Your Honor, on behalf of defendants Governor DeSantis, Commissioner Corcoran, the Florida Department of Education, and the Florida Board of Education. In the past year and a half, every parent has been afraid. We understand that. And I want to say this at the outset. We don't fault or criticize the plaintiff families for any of the actions they're taking. You love your children. You want what's best for your children. We respect the fact that you want to do everything possible that you genuinely believe will help protect your children. And despite the raging political debate that's occurring outside of this court, we know you came here with a principled disagreement rooted in your genuinely held beliefs. When it comes to masking in schools, this is hardly a settled issue. There's an ongoing debate over whether masks are more harmful than beneficial to children or to school environments in general. The governor's executive order recognized this explicitly. But ultimately, given historical data on COVID-19 and this ongoing debate, the governor made the policy decision to protect the freedoms and statutory rights of students and parents. And he did this by resting with the parents the decision whether their children should wear masks in schools. In this dispute, we're talking about the faces of school children. At its heart, this case involves a parent purporting to decide what covers the face of someone else's child.
Doesn't it really determine the safety of school children first?
We will present evidence of exactly what the court is addressing, Your Honor.
Okay.
The Florida legislature and the governor believe that there should be a very strong justification for covering the faces of school children over the objections of their parents. They concluded, on due consideration of the science, the health, and the state's educational mission, that mandating the covering of children's faces was not justified here. The executive order and emergency rule protect the rights of parents to make health and educational decisions for their children. And in this context, expressly provide the freedom for parents to choose whether their own kids should have their faces covered at school. The executive order and emergency rule had a rational basis. They were data-driven, and they followed the science. Now, as a legal matter presented in this court, we will show that the executive order and emergency rule were enacted in accordance with the Florida Constitution and Florida statutes. We'll also show that both the executive order and emergency rule further a legitimate governmental purpose, that is, protecting parents' rights, and that it's reasonably related to achieving that purpose by giving parents a choice about their children's use of masks at school. In a challenge that the plaintiffs are making here, constitutionality is presumed, and it must be construed whenever possible to affect the constitutional outcome. To overcome this presumption, the invalidity must appear beyond reasonable doubt. And case law explains that plaintiffs have the burden of proof to show unconstitutionality by negating every conceivable basis for upholding the law. Now, the plaintiffs disagree with the state's policy promoting parent choice, but disagreement with that policy is not a legally sufficient basis to set aside the executive order and emergency rule. The plaintiffs cannot, Your Honor, carry the heavy burden of demonstrating that there was no conceivable rational basis for the executive order and emergency rule. Astonishingly, the plaintiffs have asked this court to hold that a Department of Health emergency rule violates the Florida Constitution. But they didn't sue the Department of Health, which isn't even a party to this case. And Judge Dodson didn't address this in his opening comments. The plaintiffs did not include an indispensable party. They didn't exhaust their administrative remedies. They didn't even attempt to. And so for all of these reasons, and for the reasons recently argued in the motion to dismiss, we're going to ask the court to enter judgment for the defendants. Our evidence that we're going to present to the court is straightforward, and we're going to present it in three parts. First, because the executive order and emergency rule are grounded in science, the court will hear from Dr. Jayanta Bhattacharya from Stanford University. Second, Chancellor Jacob Oliva, the Florida Department of Education Division of Public Schools Chancellor, will testify regarding his oversight of a comprehensive system of care that promotes school safety. And third, because the executive order and emergency rule reflect the policies promoted in the Parents' Bill of Rights, the court will hear from parents. Like the plaintiff families, these are parents who care equally about promoting the best interests of their children. Let me summarize briefly for the court the evidence these witnesses will present. And let me ask my colleague to put up on the screen a couple of PowerPoint slides that we're going to use in connection.
Hold on a second. I think I have done this before, Mr. Abel. Let me enable that. Hold on, wait a second. Share screen. Share. Oops. Since I'm screen sharing, I hope you can still see me. I can now see 4 of you, but I can see you, Mr. Abel, so go ahead.
You can share his screen.
Your Honor, this is Mike Abel. If you can allow it so that participants can share their screen, then we can put our presentation on the screen.
All right, hold on a second.
Thank you, sir.
Let me see here. Okay, multiple participants can share simultaneously. I think I've done it. Let's see if that works. Okay, I can see it.
Thank you. Thank you for making that.
All right.
Your Honor, on the science, the court will hear from Dr. Bhattacharya, professor at Stanford University. Based on his in-depth analysis of data from multiple studies, he will explain that the forced masking of young children has a negligible impact on COVID prevalence and spread. He will provide his opinion that there is no high-quality evidence supporting the proposition that requiring children to wear masks in schools is effective in slowing the community spread of the virus. He will also explain, Judge Cooper, how the overwhelming bulk of scientific studies that have examined the topic find that children play a limited role in spreading COVID-19 infection to adults, and that children themselves face minimal risk of poor outcomes if they should become infected. And he will tell the court that this conclusion holds even in situations where children were not required to wear masks. He will testify that in places where masks were not required, schools were low-risk environments of disease spread. Now, Dr. Bhattacharya goes further and has analyzed the harms to children from wearing masks, and he will share these opinions. In contrast to the poor quality evidence that masking children in schools has any effect whatsoever on COVID-19 disease spread, he will tell the court there is ample evidence of some physical and developmental harms to children that accrue from wearing masks. Mandating children required to wear masks cause them to experience immediate side effects. And he'll talk about this: speaking difficulties, mood changes, discomfort breathing. Students with special needs are actually harmed by mandatory masking. And he will testify as an expert and relate what many school teachers in Florida probably already know, and that is masking reduces the ability to communicate. Positive emotions such as laughing and smiling become less recognizable, and negative emotions get amplified. Bonding between students and teachers takes a big hit. And masking also exacerbates the chances that a child will experience anxiety and depression, which are also at pandemic levels. The bottom line, what you'll hear from Dr. Bhattacharya, Your Honor, is he'll explain that there is no scientific or medical reason to require masking in school children, and that by contrast, there's considerable evidence that requiring children to wear masks all day at school correlates with harms to their learning and development, both physically and psychologically. We're also going to present evidence about what the actual experience has been in Florida. The executive order stated in one of the whereas clauses that the court asked me about last week, it stated that there was no statistically significant evidence to suggest that school districts with mask requirements fared any better than those without mask requirements during the last school year. And so our next witness, Chancellor Oliva, will validate this from his professional perspective. He will testify that he regularly interacts with superintendents from school districts that had mask mandates, as well as superintendents from school districts without mask mandates. And from his perspective, there was no significant difference that would compel mask mandates. And this comports with the data. And so let me show this to the court. And this is going to be an exhibit we're going to present. Your Honor, there's 67 school districts in Florida. Last year, 40 of them had mask mandates. 27 of them did not have mask mandates. And the state asked school districts to report COVID cases. And then the state compiled the data. And based on the actual data of reported cases from all of Florida school districts, that's 40 of them that had mask mandates and 27 of them that didn't. There was a very minimal difference in the amount of students testing positive for COVID in mask mandate districts as opposed to those without mask mandates. And this graph—
Who was higher and who was lower?
Yeah. So yeah, and I'll walk through it briefly here, and then
Okay.
we'll have testimony about it.
All right.
And the graph, and to the court's point, the graph is a little busy, I understand, but it illustrates the compilation of that data. On the y-axis along the left side, it shows the number of positive COVID cases per 1,000 students. And the x-axis shows the 67 school districts in Florida. The green bars represent—
You've already demonstrated, Mr. Abel, why I transferred from engineering into law.
Yeah,
by referencing the X and the Y axis. Next, I have to tell you that I am colorblind, so I don't know which one is green and which one isn't.
I'll summarize the evidence, and then we can present it in a different form so that the court—
All right. Okay.
But here, so what the evidence will show in the bottom line, Judge. For example, Alachua County had a mask mandate. It had around 48 COVID tests, positive COVID tests per 1,000 students. Hernando County, without a mask mandate, had 40. Putnam County, with a mask mandate, had 60 positive tests per 1,000 students, while Columbia County, without a mask mandate, had close to 50.
Wait a second, what was the second one? Alachua versus Hernando. What was the—
It was Putnam and Columbia.
Putnam's over there southwest of Jacksonville, right?
Correct, Your Honor.
And Columbia County's Lake City?
That's correct, Your Honor.
Okay.
And I'd say the other notable conclusion from this graph is that the Florida counties with the 4 highest numbers of positive COVID tests per 1,000 students all had mask mandates. And those are the 4 at the far right side of the chart. So across the state, school districts with mask mandates had roughly 48 out of every 1,000 students test positive for COVID over the course of the school year. And school districts without mask mandates had roughly 50 students out of every 1,000 test positive for COVID over the course of the same school year. The difference in the number of COVID cases between school districts with mask mandates and school districts without mask mandates was less than 0.5%. And we'll present testimony about this in the trial. Chancellor Oliva will also testify that the Department of Health emergency rule that's before the court provided provides welcomed certainty and consistency to school districts, many of which have no intention of imposing mask mandates. He will also discuss the many types of accommodations that occur in school districts every day to promote safety. And he will explain that there's far more that goes into promoting safety in schools besides masking. Now, finally, and most importantly, Judge, the court is going to hear from parents. And these are, and look, the plaintiff families are passionate parents who care deeply about their cause, but be assured the same is true for the parents who will testify for the defense. And representative of some of this testimony that the court will hear, and we've put a couple of things on the screen, and this is representative of the testimony that the court's going to hear. A parent: I appreciate that you're allowing me to make the best decision for my child regarding mask wearing. A teacher who's also a parent: I've watched children at my elementary school struggle so much, socially, emotionally, and academically. I'm so grateful for the freedom to select whether or not we choose to wear the mask. We all need to see each other's faces. We need to see each other's smiles. And in addition, a Manatee County parent: we're so happy that we can send our kids to school without masks on. My second grader was so happy when I told her she didn't have to wear a mask to school this year if she didn't want to, that she screamed in excitement. And this is what you're going to hear from parents, Your Honor. Thank you so much for giving parents the choice to do whatever best for their families. My children know that if they see other kids wearing a mask, that it's okay because it's their choice, just like it's our choice to not wear one. So in the context of this case, Your Honor, and the legal challenges asserted, why does this evidence matter? These considerations, science, real life experience on the ground, and the rights of parents to make decisions in the best interest of their children when it comes to two of the most important things in their children's young lives, their education and their health, all of this has been assessed, weighed, and evaluated by the representatives in the Florida legislature when they enacted a Parents' Bill of Rights, by the governor in issuing the executive order, and by the Surgeon General when he issued the emergency rule. We understand that plaintiffs want mask mandates, and to try to achieve this goal, the plaintiffs come into court and argue that the executive order and emergency rule improperly deny local school districts some perceived right of self-governance, that somehow state government has trampled on the rights of local school districts. Judge Dotson explained that that was the plaintiff's position in his comments just a few minutes ago. Your Honor, there is, as we will show, no legal support for plaintiff's position as it relates to mandated masking. And as the court listens to plaintiff's evidence during the plaintiff's case, we believe it's significant to keep a few key legal concepts in mind. The State Board of Education, a constitutional entity, has the supervision of the system of free public education as is provided by law. That's Article 9, Section 2. We talked about it last week and the court had questions. Local school districts do not have plenary authority to establish local education policy. We summarize this in our motion to dismiss, but the text and structure of the Florida Constitution demonstrate that the state legislature has both primary and preemptive authority over the state's public education system. And we'll present this again at the conclusion of plaintiff's evidence, because plaintiff cannot prove its case based on its position that local school districts have some inherent right to enact mask mandates. They don't. It's legally baseless. Now, we recognize there can be friction between the school districts and the State Board of Education. This isn't the first time that it's happened, and it won't be the last. But the first DCA has settled this issue, and it's addressed this issue. And it wrote in School Board of Collier County against Florida Department of Education, the Florida Constitution creates a hierarchy under which a school board has local control, but the state board supervises the system as a whole. The state's broader supervisory authority may at times infringe on a school board's local powers, but such infringement is expressly contemplated and in fact encouraged by the very nature of supervision by the Florida Constitution. So Judge Dotson talking about this infringement on some ability of local school boards to enact mask mandates independent of the state.
For the rest of the lawyers, Mr. Abel, I think that's a case in which I was affirmed on the substantive nature of my ruling, but reversed on whether the plaintiffs had standing.
Your Honor, we will show that all of the state's actions were in accord with both the Florida Constitution and Florida statutes. The governor, consistent with Article 4, Section 1A, Sections 20.03, 4, and 13, and his executive order. He issued the executive order to ensure that the Department of Education and Department of Health implemented appropriate safety precautions without infringing on parents' rights. It did not direct any action towards specific parents or any school district. The Department of Health, it operates under the direction and supervision of the governor. And we've cited this law in our brief and on our slide. And it implemented the emergency rule pursuant to 1003.223